Cases number 115, People versus Edgar Correa, 137, People versus Alan Mack, 124, People versus Desiree Wilson, and 120, People versus J.O. Fernandez. Okay. All right. The appellants on this side, the respondents on that side. Mr. Calandra, I think you're over here with Mr. Ferdenzi. Okay. Mr. Ferguson's over there. Ms. Whetstone, Mr. Lucenti, you're here. And Jody Mandel, you're there. Okay. All right. So, Mr. Ferdenzi.
Yes. Good afternoon, Your Honors.
Good afternoon.
Joseph Ferdenzi, representing the people of the state of New York in the Correa and Mack cases.
Okay.
Back in 2004, court administrators saw a problem, and they tried to address it.
Okay.
The problem they saw...
We know the history. We know the history. Let's just get to the legal issues, because that's what we really have to deal with. There's a claim here that the court administrators bypassed the legislative process and were without authority to issue these rules. So let's just get right into that and tell us why they did not.
Well, the reason they did not is because they had Section 19 of Article 6 of the Constitution, which regulates the transfer of cases between courts, and that provision requires that there be a law that permits the transfers and that it will promote the administration of justice. And as Chief...
If that weren't there, if you just had Article 6, Section 28, would that be enough authority for what happened here?
Well, Articles 6, Section 28 that you referred to does not have a triggering provision for transferring cases, unlike Article 6, Section 19. It's pretty clear in this case that everyone agrees that the Supreme Court can exercise jurisdiction over misdemeanors. The nub of the question is, how do you get the cases in Supreme Court?
Right.
And Judge Kaye's order specifically refers to Judiciary Law Section 211, which memorializes the Chief Judge's constitutional powers to regulate administrative activities, and specifically contains a provision about the transfer of judges and causes among the courts.
So you need both constitutional provisions.
Well, I think the entire constitutional framework, both 19A, 28C, Section 30 of Article 6, all go to the power of the chief administrative judge, the chief judge, and in this case we also, of course, have the administrative judge for Bronx County.
Even without what the chief judge and chief administrative judge, without their rules, did Supreme Court under the Constitution always have concurrent jurisdiction with misdemeanors?
Yes.
Well, that's because Supreme Court is a court of original trial jurisdiction, correct?
Correct. That is correct, Your Honor. And that...
So the issue distills then to something else, how
to get the cases...
How to get the cases there?
Before them. And before the First Department, we argued that the triggering law was Judiciary Law Section 211, and the First Department disagreed. And they felt that former Chief Judge Kaye and former Chief Administrative Judge Lippman and everyone in that sequence had overstepped their bounds because of the provisions of Criminal Procedure Law Section 210.05.
Well, isn't that what this boils down to, how you read that provision, whether you read it as jurisdictional or not?
Correct. And and not only is it not jurisdictional, Your Honor, but it is a section addressed to what prosecutors can do. I mean, the section itself refers to prosecuting an offense, which is obviously something prosecutors do. It refers to instruments filed by the district attorney. Obviously, if the chief judge is to administer the transfer of judges and causes among and between courts that have jurisdiction over cases, because here we're talking about a Supreme Court that has jurisdiction over misdemeanor cases and a criminal court.
This is just a procedural rule. This doesn't go to the jurisdiction of the court, even though we have some commentators who have said otherwise.
Correct.
Professor Preiser, I understand, says otherwise.
That's correct, Your Honor. That's a sum of it. And,
Is Professor Preiser talking about subject matter jurisdiction
well,
as opposed to
honestly,
concurrent? If there's no subject matter jurisdiction, it means if it's a defective accusatory instrument,
right.
neither
Yes.
court may
Right.
have jurisdiction.
Correct. But here, there's never been any contention that these are defective accusatory instruments. That's never been the case. So we have a Supreme Court that has subject matter jurisdiction over misdemeanors.
Can I take you back for a moment
Yes.
to Judiciary Law 211?
Yes, Your Honor.
It authorizes rulemaking, but it talks about standards and policies for general application to the unified court system throughout the state.
Correct.
Is there a problem that this is applicable only in the Bronx?
No, Your Honor.
Why not? What meaning do you give to those words
Well,
for general application to the unified court system throughout the state?
Well, the meaning that section carries is that they are standards and rules intended for general application in the courts that need it. You wouldn't, of course, implement a plan like this in a county that did not have the problem that the chief judge was trying to address.
I guess maybe my question is, would the section mean something different if those words weren't in there?
Not really. I mean, it talks about general standards as opposed to case by case.
That sort of raises the question why the legislature went to the trouble of writing it.
Well, because I think they were talking about general standards as opposed to case-by-case rules. And
What about the words throughout the state?
Well, this program that they came up with, Judge, it just so happens we were fortunate enough to be picked first. But that doesn't mean that it was intended solely for Bronx County. And the fact that it isn't being applied in all 62 counties of this great state doesn't mean that the chief judge used this section improperly.
Well, there have been many pilot programs throughout the state.
Correct.
That
And
the
we-
former chief judge and the current chief judge have instituted.
Yes.
That involve some sort of merger. We have our domestic
Mr.
violence.
Fredette,
I'm sorry.
I apologize.
No, go ahead.
I was trying to focus on how this exactly happens. If I understand your argument, if the people of the state of New York want to bring an aggravated harassment charge against somebody, they can't bring it in Supreme Court unless they do it by indictment or they get it as Superior Court information.
If the people want to.
Right.
Correct.
So they have to bring it in the local criminal court.
Correct. Initially, correct.
Right. And once they bring it in that court, what happens? I mean, is the Bronx criminal court now just an arraignment part?
No, we also have other parts where cases are tried. In fact, one of the cases that we were asked to brief by the First Department was later sent back to the appellate term because it was tried in criminal court post the transfer orders. So the criminal court, as presently constituted in Bronx County, has fewer parts, but it has not been eliminated.
What do they do?
They still have jurisdiction over B misdemeanors and unclassified misdemeanors
Well,
and violations?
They still, the criminal court still.
Where do those go?
Okay, well, the criminal court still enjoys the same jurisdiction it had before these transfer orders. It's just that the cases, some of the cases are no longer tried in criminal court parts.
Well, that's my
Right.
question. If I've got like a DWAI violation, is that going to stay in the criminal court or be transferred to Supreme Court?
If I understand that, I'm sorry, Your Honor, sometimes in different counties we use different terminology. Is that driving while
Driving while
impaired?
ability impaired, the violation.
Right, the violation. That would stay in criminal court.
So they can still do trials
Yes.
for anything less than the A misdemeanors.
Yes,
And they still
exactly.
do the arraignments on all the misdemeanors?
Yes, Your Honor.
And felonies. They do
Yes, and they
arraignments on
still,
everything.
yes, right, exactly.
So going back to my aggravated harassment case, the judge is sitting there asking you how you plead not guilty, and he's done.
No. In arraignment, Your Honor?
Yeah, he's arraigned it.
Right. No, it's not done. The case then gets adjourned into a Supreme Court part.
That's what I mean. So
Yeah.
he says, thank you very much for coming. It's now 9:45. I'm going home. right?
After he finishes 100 cases on the docket.
Yeah, well, can you all raise your hand, plead not guilty, and I'm sending you all to...
Well, I assure you that the judges of the criminal court who handle arraignment parts in the Bronx are quite busy.
But no, I'm just curious in terms of, I mean, if I was elected to put me in the city of Buffalo. I mean, if we did this up in Buffalo, what you'd be saying to the 12 or 13 judges in the city, remember how you used to do all this stuff where you're not going to do it anymore. You're going to be there at 9:30. You're going to arraign these people. If they plead not guilty, you are going to lose jurisdiction. So you can get your golf clubs out a little earlier than you otherwise thought. Now, I'm not suggesting that they're not otherwise busy with criminal stuff. But isn't it kind of a limiting thing for these judges who used to handle these to be told you are now no more than a B misdemeanor in violation court and or civil, because they do some civil?
Well, Your Honor, in fact, what happens is the judges who preside in arraignments do so on a rotating basis. Then, when they're assigned to a Supreme Court part, they preside over the trials of...
They become acting Supreme Court.
Correct. They become acting Supreme Court judges, and then they preside over the trials of felonies and Class A misdemeanors. So they're quite busy. And the whole purpose...
Is it a... I mean, it may not be dispositive, but is it a fact that criminal court judges, as criminal court judges, when they're wearing their criminal court hats, are less than fully employed?
Your Honor, I don't think the question could be put that way. They're fully employed. They're working in arraignments when it's their turn to work in arraignments. They're presiding over...
You're saying you really don't care what hat they're wearing as long as they're fully employed?
Oh, they're fully employed. Yeah. And that was the whole purpose of this transfer plan, was to fully employ everyone to share the load. Because fortunately, due to the reduction of serious crime in the Bronx, we had a reduction in felony dockets. But we had an increase in misdemeanor cases. And those...
Presently do preliminary hearings. Do you still do preliminary hearings, or is that...
No, Your Honor.
Is that got as a result of this, or that...
No, that was...
had fallen out a long time ago?
Yeah, right, Your Honor. That was...
Did I remember...
That was done away with independently many years ago.
Did I recall correctly from the record, is there over 750,000 arraignments a year? Somehow I'm remembering that...
750,000? I don't think that's the number, Your Honor, but it is substantial. It's in the tens of thousands, for no question about it.
And that includes all the felony arraignments on complaints, correct?
Yes.
So really what this does is it takes the city court judges and makes them supremes. You're not saying to these misdemeanor courts, you now have less to do. What you're saying to them is, we're going to make you acting
Correct.
supremes, and in order for you to keep the work that you had before,
Right.
we're going to need these transfer orders to keep them in front of you, and then you also get what's coming out of
Right.
grand jury.
And also the purpose is to have the elected Supreme Court judges handling more of the caseload, the combined misdemeanor and felony caseload. And so, as Judge Kaye's order says, it's to promote justice and to better utilize the resources in a particular county that has this problem. And the reports, they're a little bit mixed right now, the results, but it did speed up the disposition of misdemeanor cases because it made more judges available to try the misdemeanor cases, which were languishing because of the lack of available resources. So this plan definitely promoted the administration of justice in Bronx County, and were it to be used in other counties would probably work the same way. But as has already been indicated, it just so happens we were chosen first to see how this program would work.
One difference here is that the appeals, instead of going to the appellate term, now go to the appellate division.
Correct, Your Honor.
Does that change anything in the scenario?
It doesn't. It has no significant change as far as I can tell. I mean, we still have to respond to these appeals just as we were responding to them when they were in the appellate term.
Yeah, but think of the judges. In other words, if we have a case on in which there's a justice court in the town of Batavia, all right, and there's a decision made. The appeal there goes to the county court of Genesee County and then to us. If Genesee County had your system, it would go from it would be a county court case, and it would go to the appellate division. The county court would not sit as an appellate court. They'd be sitting as a court of original jurisdiction on the case, and then it would come to us. So the appellate divisions are going to get more work.
Well, theoretically, that's true.
We sympathize with those people.
Right, right. I understand, Your Honor. Theoretically, that's true. But because, as I related, we've had a reduction in felony cases in Bronx County, there are fewer appeals from felony cases going to the First Department. So it's a bit of a wash.
Are things pretty slow in the appellate term?
Oh, they've got plenty of landlord-tenant cases, Your Honor, to deal with.
So-
They're very busy there. And I see my time is up.
And did I ask you if you wanted to reserve time, Mr.
You know, I forgot to
Jensen?
ask, Your Honor. I don't know if I used up all my 15 minutes. If I did, so be it. That's okay.
All
Thank
right,
you.
well, then I'll ask Mr. Kolodner if he wants to reserve time, since he's on the same side.
Thank you, Your Honor.
You're welcome. Okay. Do you want to reserve time? The red light comes on awfully quickly.
I'd like to reserve 2 minutes.
2 minutes, all right.
There are just two requirements that we need for all our problem-solving courts. They have to have the jurisdiction to hear the case, and there has to be a method of properly transferring these cases into those courts. Jurisdiction with the Supreme Court, actually, under the Constitution, is general original jurisdiction. The Supreme Court will always have the jurisdiction to hear these cases, but if the respondent's argument here is to be taken that 210.05 essentially says there's no jurisdiction, then the only answer would be that 210.05 can't be read that way, because otherwise it would not be constitutional.
What about the legislature's reserved power under Article 6, Section 30, to regulate practice and procedure?
This is not practice and procedure. This is pure administration.
All right.
Are you saying the legislature is powerless to regulate this?
Oh, no, the legislature can regulate administration, too. But this comes under the Section 28 power for administration, and we have to work in terms of Section 28.
Could the legislature restrict the transfer? They can't diminish the general jurisdiction, but I suppose
Well, the
if they
jurisdiction-
wanted to, they
the
could.
legislature can
they
fix
could
jurisdiction,
restrict the
that's a Section
transfer.
30 power. But the Constitution, in most respects, determines the jurisdiction of all the courts, and the legislature obviously can't change that without a constitutional amendment.
Could you commence a misdemeanor complaint in Supreme Court?
Not under this current system, no.
Right. So, I mean, there are limits.
There are limits. There are certain statutory, procedural, constitutional limits.
Suppose theoretically suppose you're right, that the pure jurisdiction is not an issue. But suppose you're wrong about whether the procedures have been complied with. Suppose there is a procedural violation, that is, that these transfers were effected in a way that the statutes and regulations don't permit. Would that be a jurisdictional issue, or would that be an issue that required preservation, like any other error?
I can't speak to preservation. What I can speak to is that there has to be, you have to fulfill the requirements of Section 19 of the Constitution here. That's the transfer provision. We have jurisdiction, but did the Supreme Court get it properly, because it came in as a transfer, it didn't come in as an original case? And yes, if the legislature sets forth a statutory scheme for the transfer of cases, because that's a constitutional provision that has to be complied with, yes, we have to follow those transfer provisions. But what the legislature
But
did...
would you characterize a failure to follow them as a jurisdictional flaw?
No, I wouldn't characterize it as a jurisdictional flaw. It's a procedural flaw. But the transfer, interestingly enough, gets here because, well, number one, the CPL is already given, leave aside the Constitution, which is clear jurisdiction of the Supreme Court. The CPL places jurisdiction over unindicted misdemeanors in the superior courts, in the jurisdiction provision. It's concurrent jurisdiction with the local criminal court. So once that's there, and it's clear there, and there's no limitation with respect to the divestiture of these unindicted misdemeanors from the local criminal court up to the superior court. It allows that without any restraint whatsoever. So if you look to 210.05, which is what the appellants are basing, respondents are basing their entire argument on, you see that it cannot be read to be contrary to a jurisdictional provision in the CPL itself.
That may be true, but one of the things that popped into my mind, because I think more of civil than criminal, is that if you begin an action in Supreme Court, let's say for pretrial discovery, you have to get an index number, and you get it. You get your pretrial discovery, now you're ready to start your lawsuit. You start your lawsuit, and you get greeted by a motion to dismiss your lawsuit because you're using the same index number that you used for the discovery, which makes absolutely logical sense, except in the courts of the state of New York. And your case gets thrown out because you didn't buy an index number. You get thrown out. Now, it seems to me that if that is of such stature that you can have your case dismissed because you didn't pay the money for a second index number on the same case, why wouldn't it equally apply here when you're talking about how you have a criminal action in Supreme Court when the CPL clearly says that there's two ways to do it, by SCI and by indictment?
Well, but there's a third way. The third way to get a misdemeanor into Supreme Court is to go the route of transferring it pursuant to 19A, to allow the Supreme Court to reach down and pull out cases in the interest to promote the administration of justice, and that is another way of doing it. That's basically what happened here.
And that's self-executing?
No, it's not self-executing. That's what Section 211 is all about. You know, what's interesting here is that there's a provision for jurisdiction for the pull-up in the divestiture in the Supreme Court, there is nothing in the CPL, there's nothing in the CPL that creates a procedure for pulling this case up. There is a procedure with respect to motions by the district attorney with regard to a continuance so it can move for an indictment. There is a procedure for a motion by the defendant to ask for an indictment. But there's nothing for the pull-up. And why isn't that in the CPL? It's not surprising it's not there, because when you're talking about a court pulling up something in its own discretion, you're talking administration, you're not talking procedure.
Well, but you could make the other argument that the reason is because there is no provision for that, and the only way to get a misdemeanor in the Supreme Court is by SCI or indictment.
You could make that argument, but it would not be correct.
Because you say there's this umbrella, you're not offending the Constitution if you're saying, yes, you have general jurisdiction, and here's the general jurisdiction, SCI and indictment. You've got misdemeanor jurisdiction. It's just that we're telling you the kind of paper that, the way you commence it. And I apologize for putting this right next to it, but why is that? I mean, why are misdemeanors required to be commenced by SCI or indictment in Supreme Court, Superior Court?
Well, why in Supreme Court? Well, because
in Superior Court.
In Superior Court, because I believe that the Constitution requires that any case tried by an indictment be tried in Superior Court.
No, but it says if you're going to bring a misdemeanor in Supreme Court, part of your argument is that this is directed to prosecutors.
Yeah.
They can't bring an aggravated harassment case in Supreme Court unless they do it by indictment, and they can, or by SCI, and they can. Why?
They can't.
Well, why is that limitation put on prosecutors? Well, what was the policy the legislature thought it was advancing when it imposed that limit on prosecutors?
I would think that in general, with the prosecution would, well, really, it really comes down to why do you have to, why would you want to bring a misdemeanor by an indictment anyway? Because once you have an indictment, then you have the grand jury of 23 people making a decision that you can prosecute the case.
Because it's part of a grand scheme. In other words, you got a grand larceny and a petty larceny and a bunch of stuff, so you throw it all in front of the grand jury and you indict it all.
Yeah, well, it's a way, frankly, for the district attorney to take a very controversial case and say, this is not all my decisions.
Well, that's cynical.
Okay. All right. Thank you, Mr. Plano. You'll have your 2 minutes. All right. On behalf of defendant, Mr. Ferguson, you're going to be arguing defendants Correa, Mack, and Wilson, correct?
I would like to, since Ms. Wilson's case is somewhat different, we'd like to simply address Mr. Correa and Mr. Mack now, have Mr. Collender respond, and then come up again for Ms. Wilson, because it's a different factual situation.
All right. Well, you have 25 minutes. Right. So how are you going to divide it up?
I would divide it into, we would take 20 minutes now, and as for Ms. Wilson, would be just 5 minutes,
okay,
which is what we had originally asked.
All right. So you have 20 minutes. All right. Go ahead.
Your Honor, what really boils down to here is exactly what the appellate division did, is it gave meaning to everything. They looked at the principles of statutory construction and gave meaning to all of the provisions. What the people are doing and what the Office of Court Administration is doing is essentially attempting to make CPL 210.05 a nullity. That it no longer, it has no meaning, and
Do you say that 210.05 restricts superior court jurisdiction?
Absolutely, Your Honor.
Can it do that? I mean, when the Constitution confers general jurisdiction?
What is happening here is that they have to be read together. And what the constitutional provisions, along with CPL 1020 and 1030 do, provide information as to where things could possibly be heard. 210.05, as the appellate division rule, makes the determination as where it is actually heard. And the provision that says the only method to which this can be heard in the Supreme Court is either by indictment or superior court information.
Could the legislature enact that no misdemeanor of any kind can ever be heard in Supreme Court?
I believe they could, because that would be essentially be revamping.
Why did the authors of the Constitution write in the Supreme Court shall have general criminal jurisdiction, felonies and misdemeanors?
It's that they have general jurisdiction, but then they take a look at what they did in 10.20 and 10.30 and indicated that there is concurrent jurisdiction, and then limited that in 210.05 to indicate that there is the only method by which you can go to the Supreme Court is by indictment of superior court information. And it's essentially what Judge Pickett was talking about earlier, is that they could not originate this. If the people cannot prosecute and file a complaint just in the Supreme Court on a misdemeanor case, but as of now, they can go in this backdoor fashion, is take it, go to the criminal court, which has become, in essence, a shell of itself. It has been reduced, as Your Honors have picked up, a shell of its
The number of
form.
judges, as indicated, have been moved up. They've been promoted to acting JSCs.
They have been moved up to be acting Supreme Court
You're
justices.
hearing felony cases along with misdemeanor cases. I mean, that's nice for a judge, right?
But that's as to the judge, but as to the court itself. The court has been reduced to a de facto arraignment part as it relates to misdemeanors.
There are no trials of B misdemeanors?
Relatively few. If you take a look at the New York Law Journal on
Is it unconstitutional for the criminal court to have relatively few cases?
Not unconstitutional, but what has happened here is that the court has been eviscerated, as the appellate division held in this particular case.
Well, they use the word eviscerated. If that means de facto abolished, I see your point. But I don't quite see how you can say that de facto the criminal court has been abolished. What else would be unconstitutional?
Your Honor, what they have done here is taken away the vast majority of the cases that were held in the criminal court.
Okay, I guess I'm saying, is that in itself unconstitutional, to take away the vast majority of the cases? When two courts have concurrent jurisdiction, is it unconstitutional to give the vast majority of the cases to one of them?
In the method in which it was done here, yes.
But not in itself.
That there was a way to do it, there was a legislative way to do this, and in fact, it should have been something that could have been done by Constitution.
The legislature could validly have done exactly what the Chief Judge did?
That is correct, Your Honor.
Let me ask you this. You didn't raise this initially, either in Correa or Mack.
I can explain the reason why.
Okay.
The reason why this wasn't is because of the posture, the procedural posture in which this appeal was done. Remember, in 2007, our office had originally, in People v. April Jones, challenged these very issues in the appellate term. We lost in the appellate term. Leave was denied by this particular court. So when these cases were filed in the appellate term, there was a dispositive issue, a dispositive ruling on this issue by the appellate term First Department.
But not by us. You still could have raised the issue.
But this Court had already
No, it was just denied leave.
It was denied leave.
We didn't decide the issue.
But that was essentially the reason why it was not raised, because it was not, we would have no basis to win in the appellate term.
And then you were asked by the appellate division to brief these issues?
It was actually raised at oral argument in People v. Cepeda. In fact,
Where is that case? Where is Cepeda?
People v. Cepeda was the one of the 36 cases that were pending, that were transferred by the amendment to Rule 143 when they rescinded the original order and allowed, and then said that it had to be heard in the appellate division. I mean, what you had there was an indication by the now Chief Administrative Judge that the original rule promulgated by the former Chief Administrative Judge was, in fact, running counter to what was allowed under the Constitution.
Just out of curiosity, what's the downside? I mean, I understand that these things could be brought by SCI or indictment, and you'd be in the same place you are now. And I understand your point by, them, if you want to call it a back door, by just going down there, getting the arraignment and then getting the transfer. But what's the downside for the defendants?
Downside for the defendant of having it being heard by virtue of this?
Being in Superior Court as opposed to City Court.
Part of what's going on is by determining that they can go in any way that they wish, they make a determination as to whether or not this can be heard by a bench, whether it can be heard by a 6-person jury or a 12-person jury.
Well, they can go the prosecutors can go any way they wish?
That's right, because if they had chosen in the misdemeanor, if they had chosen to seek indictment in these misdemeanor cases in the Supreme Court, we would be entitled to trial by jury. By going the method they do, and if it's a B misdemeanor, they would not have that right. So they're making a determination.
You're saying the practical effect of this, from your point of view, the damage is this gives the prosecution the option of a non-jury trial in Supreme Court.
Absolutely, Your Honor. That is
They're
one.
only trying, a non-jury trial in Supreme Court of a B misdemeanor? You wouldn't be entitled to
Right.
a jury.
Right. But I'm talking about as for the A misdemeanors, by going.
But you would get a trial in criminal court for an A misdemeanor. It would be a 6-person jury, but you'd get a trial if you requested it.
But, Your Honor, if it had gone by indictment.
Unless they reduced it, but then that's to your client's advantage because your client then can't get a year, can only get up to 6 months.
That is correct, Your Honor. But what we're talking about here is that you're giving absolute discretion to the prosecutor to determine what type of rights the defendant has at the trial by how they're going to proceed in this, which goes back to our original point that this is jurisdictional in nature.
All right, well, I have a question because I really don't know the answer to this question. When an A misdemeanor is tried in Supreme Court, is it a 6-person jury or a 12-person jury? I don't know the answer to that question. Because if it were tried in criminal court, it would be a 6-person jury.
If it is by the current, if it has gone this way, it is a 6-person jury. If it is by indictment, it's a 12-person jury.
But that's because it's usually linked with a felony or something else, right?
But again, Your Honors, in 210.05, that they can pursue a misdemeanor indictment, and if they do it by misdemeanor indictment, they do get a 12-person jury, irrespective of whether or not.
I guess the question is, what are they getting without the indictment? An A misdemeanor that the trial is conducted by an acting Supreme Court
That would be
judge. Are they getting a 6 or a 12-person jury?
A 6-person jury. And if it's by indictment, they get a 12-person jury.
So there's not a disadvantage to the defendant?
I believe there is a disadvantage to the defendant. A 12-person jury, I think we believe that a 12-person jury is fairer to the defendant than a 6-person
But
jury.
before this new system, if you're only charged with an A misdemeanor, it would go to criminal court. You'd only have a 6-person jury anyway. It's only when that A misdemeanor is attached to a felony and it was indicted.
Well, you could have sought a misdemeanor indictment. You don't have to just seek a
How
felony.
often is that done?
It is not done very rarely. And I just wanted to go back to Your Honor to ask what happened to Mr. Cepeda.
Yes.
Mr. Cepeda was one. There were 36 cases that existed at the time of the rescission of 143. Of those, 35 of them were misdemeanor appeals, misdemeanor convictions.
You said you were at oral arguments.
Right. And Mr. Cepeda's case, that was an actual VTL, one of the few trials that are actually happening now in the criminal court. are the VTL cases, as opposed to, there are relatively few B misdemeanors. Those are usually A misdemeanors that have been reduced to B misdemeanors in the Supreme Court now. And what happened at the argument in Mrs. Cepeda's case is the court asked questions of both myself and the people as to whether the court had jurisdiction over the case and how they should rule on this. Actually, the first question Judge Andreas asked me was, why are you here? And my thought, of course, first was...
As opposed to being the appellate term?
My first thought, of course, was, well, you ordered me here, so that's why I'm here. But then it got on to what he was going at as the jurisdictional issue, and we said that if the court had wished for additional briefing on this, we would be happy to do so. And several days later, both myself and my adversary got letters from the appellate division asking us to brief two particular issues, which we gave the specific terminology in our brief, and they did it for the three cases that were common to Justice Andreas at the time, which was People v. Correa, People v. Mack, and People v. Cepeda. Only after it was further proceedings and my adversary in Mr. Cepeda's case noticed that, in fact, it was a VTL case that actually was heard in a criminal court, and eventually the appellate division correctly determined that that had to be remanded back to the appellate term, where that case is still pending for, I guess, additional argument.
Can I ask you a question about the IDV stuff? The same process applies, right? You're arraigned on the let's say the misdemeanor assault involving your spouse or something like that, and then it's transferred up to the Supreme Court?
I believe that's the case, Your Honor.
Does it happen that transfer can go to a Supreme Court judge who's actually hearing a civil matter, and I'm, of course, referring to a divorce?
Your Honor, that is what's in Mr. Lucente's case and Mr. Fernandez. I don't know the answer to that particular case. I know he knows the answer to that particular case, but they did not have the IDV part, was not part of this particular appeal. And Mr. Lucente will obviously address that.
No, but you did get a contrary decision from the second department versus the first department.
Yes, they did.
I presume you did read that.
Yes, oh, absolutely, Your Honor.
So where do you think they went wrong?
I think they went wrong in a number of different ways. They were reading 211 as being the determining factor. I don't believe that they read the entirety of the statutes together. That part of what's going on here is you have to read all of the statutes together to come up and make sense out of all of them. I think what the appellate division did in the second department in Fernandez was to pick and choose and relate to specific provisions, and therefore they did exactly what the appellate division first department didn't do. They did not. They rendered 210.05 a nullity.
Well, if you didn't have 210.05, would we be here?
I would think not.
Let me ask
I would think
so
that
the question is what's the scope of that, what's the purpose, and how much weight to give that statute?
Absolutely, Your Honor. And I think the position that Amakai is taking in terms of that we're going to look at, because 10.20 and 10.30 are in a section that are entitled jurisdiction, that in and of itself, that's all that's jurisdictional in this criminal procedure law, just ignores the basic canons of statutory
Let me ask you a slightly different question. I was, a while ago, I was asking Mr. Fredenzi questions about the phrase for general application of the unified court system throughout the state in Section 211. Do you rely on that phrase?
I do, Your Honor.
So
I believe what you have here is...
You say that means that every rule has to be statewide application?
Not that every rule has to have statewide application, but you cannot pick one out of the 62 counties and treat it differently, particularly in a situation
How many, can you pick half a dozen?
I don't...
Haven't we done that with it? Hasn't the court system done that with a lot of pilot programs? Whether it be electronic filing or criminal procedures, there's quite a few different things that we try on a trial basis.
Right, but there's a difference between procedural things and jurisdictional things. It's our position that this is jurisdictional in nature. If it was strictly something that was procedural in nature, that would be something.
So you don't take the hardline position that the language I read means that every rule must be of general application throughout the state?
We won't take it as a hard-line rule, but in this...
Or maybe a soft-line rule?
In this particular case, I think what occurred in this particular situation is the judge overstepped what they could do in this particular
We have integrated domestic violence parts in many counties, but not all 62.
and I believe that they, too, have to comply with 210.05. In other words, there is a methodology that can be employed for things to work. They have not
But
done
the
that
question
here.
that Judge Smith is asking you, is there something unconstitutional about the fact that they're not in every county? That it's not statewide?
I think it would be difficult for like the integrated domestic violence parts to suddenly put them in all 62 counties. But you have to follow the jurisdictional rules to allow it to withstand this court's scrutiny. And I think that's what the problem here is they didn't follow the rules that they needed to.
If we adopt your interpretation of 210.05, what's the practical fallout? I know OCA says the sky's going to fall.
The practical fallout is far less than what they say. If you look at the number of perfected appeals of Bronx misdemeanor convictions in the past 6 years, from the time that these rules went into effect to now, it is less than 200. And
So what happens to those 200 cases?
those 200 cases, they can move.
Convictions have to be vacated?
I believe that's correct, Your Honor. But when they're talking about the number 147,762, that's an unrealistic number. The vast
That's
majority.
the total number of filings?
No, that's the
they've had?
total number of Bronx misdemeanor convictions at the time that the stay application was made in this
But we should
particular.
look at the subset of those that have gone to appeal.
Actually, the subset of those for which a notice of appeal was timely filed and an effort was made to perfect it. Under this Court's
What
ruling.
about all the pleas? Could they all come back in?
No, Your Honor. Because, again, under People Quadrato, which this Court had ruled that you had to go through the proper channels in order to challenge things on an appellate basis. You cannot go back in on CPL 440 for things that could have been raised under direct appeal. As Your Honor pointed out, that notwithstanding Jones, there was a way to still challenge that in the appellate term. So there are things that they could have and should have done, so that although the people
They can't come back in on a quorum nobis and claim they had ineffective assistance of counsel for not raising this issue?
Again, that would be the perfected appeals. You're talking about the perfected appeals where it was not raised?
Talking about anyone who pled.
Well, anyone who pled, there was probably not a notice of appeal filed. And if a notice of appeal wasn't filed, or if the defendant did not move to ask for assignment of counsel where the cases of notice of appeals had been filed, what you have is that the district attorney's office has procedural arguments to oppose those.
What about preservation?
Preservation. It's our belief that since it's jurisdictional in nature, preservation is not required in this particular case.
I thought you were going to say that.
Yes, and it is exactly what and I believe both the First Department certainly came to that conclusion as well, that this is something that did not have to be raised below.
Why is it jurisdictional, not just procedural?
It's jurisdictional because you have to read 1020, 1030, and 210.05 together to understand jurisdiction in the criminal arena. What 1020 and 1030 do is establish where a case could possibly go, where there is concurrent jurisdiction. 210.05 governs what court actually hears it. And by the plain language of 210.05, it states that the only means by which this could have occurred is if it is by indictment or superior court information. And as our position that makes it jurisdictional in nature, notwithstanding the fact that it's in a different part of the CPL. But again, the canons of statutory construction indicate that you don't go by the terminology at chapter heads. You read things all together to make meaning of them. And remember that the CPL was a comprehensive enactment by the legislature in 1971.
By the way, before I lose that thought, is there, I'm assuming everybody has scoured the legislative history, but is there anything at the time that the CPL was, was devised, was written, that would shed any light whatsoever as to whose interpretation is correct?
I don't believe there is, Your Honor. For what we attempted to do, we could not find anything that was. If there had been, that would have been like in
Well, the
old in print on ours.
1955 report on the Commission on the Courts did certainly indicate that these provisions of the judiciary law were under consideration because they wanted to be able to allocate caseload.
That is correct, Your Honor, but, the CPL comes in 1971 after that, and I think when you read all of those together, the indication is that they all are pertaining to jurisdiction.
So we have to rely on the words in the context.
That's absolutely right. When you don't have any, you have to rely on the plain meaning. And to give meaning to all of the provisions in all of the statutes and the constitutional provisions here, I believe that just as the appellate division did in comprehensively looking at it, I believe that's the correct way.
Is it your position that the phrase "as provided by law" under the Constitution refers to 2105?
I believe it does, Your Honor.
And only 210.
Yes, I believe it does, Your Honor. Because, again, it talks about that it can't run contrary to something that's established, and that is our position.
All right, thank you very much. You'll have your 5 minutes for Wilson. All right, so rebuttal on Mack and Correa. Mr. Kolodner, you're going to do that. Okay.
And Mr. Ferguson basically says you have to read all the statutes together to find out what 2105 means. But that's precisely the point. If you read all the statutes together and you look to see that there is concurrent jurisdiction in the Supreme Court, trial jurisdiction, and you look at the sections of the CPL that deal with preliminary jurisdiction, you find that 2105 is only a statute dealing with preliminary jurisdiction with respect to a superior court. Yes, then you need an indictment. And that's because it's listed in the preliminary proceeding section, and it's almost an exact paraphrase of the provision in Section 10 with respect to the preliminary jurisdiction of the Supreme Court, only as to indictments.
So it directs the people how to bring it.
That's right. That plus the fact that it only deals with preliminary jurisdiction in superior courts anyway. And as to the practical fallout, which Judge Reed mentioned, we're going way beyond the Bronx Criminal Division here. We not only have the domestic violence parts, but we have all our drug courts, every one of which takes unindicted misdemeanors and hears them in the superior court.
Your number reflects also.
Well, there is a great deal of fallout from the decision if this case were, if our courts was, if we couldn't move unindicted misdemeanors up to superior courts in these special instances, there'd be a great deal of fallout. And to answer Judge Smith with regard to general application throughout the state, that is a provision relating to the breadth of the exercise of the power. It is not a limitation on the power. It is there to emphasize that we now have a truly unified court system. Thank you.
All right. Thank you, Mr. Kolodner. All right. Now, you're the appellant in Wilson, and Ms. Whetstone is a respondent, right? Okay. So we'll
Do I have to
you
sit
on.
over here now?
No,
There's no room.
Can I have maybe 30 seconds in rebuttal then, since I'm appellant now?
All right. 30 seconds.
Okay.
Go ahead.
Ms. Wilson's case is different than what we have here, and that is that this case was transferred to the Supreme Court prior to the judge's rules.
How do we know which court it was tried in? Since we have criminal court judges who are both acting Supreme Court judges and they transferred it between themselves.
I acknowledge, Your Honor, that it would be better if there was far greater material in the record in this particular case, but what it indicates is when it was transferred, stated on the record, it was transferred to the Supreme Court.
It was a two-header. The nomenclature we use, judge, and the certificate of conviction says the criminal court, correct?
I think what you see is what is signed is Judge Gross signed it as judge of the criminal court, but the case was heard.
That's not enough?
I don't believe that was enough because it was sent to the appellate division as a Supreme Court decision. And if there are truly questions about
when you say it was sent to the appellate division, what in fact happened?
This was one of the 36 cases that was transferred from the appellate term to the appellate division upon the rescission of Rule 143. And the appellate division can only hear cases from Supreme Court decisions.
So first it went to the appellate term, and they're the ones who did the transferring. Appellate term transferred.
No, I believe the transfer is by Judge by then presiding Justice Littman of the First Department. He is the one who transferred it. It was the.
Is it possible that he simply overlooked that this was a pre-BCD case?
Your Honor, what I would suggest that if there are serious questions about who actually heard this, then perhaps the proper procedure here would be to remand this for some type of a reconstruction to determine who actually heard it, because it does make a tremendous difference.
If you lose, and if we find that it was really the criminal court that heard it, don't you get a shot at the appellate term?
That's exactly where I was going with, Your Honor, that if the situation was that this was heard actually by the criminal court, the appellate division had no jurisdiction over this particular case, and it needs to be remanded to the appellate term for essentially de novo appeal. But I think because even Amici indicated in response to Judge Piggott's question earlier in the proceedings today that you could not originate a case in the Supreme Court on an unindicted misdemeanor.
Apparently, Judge Oliver said, he was then the supervising judge of Bronx Criminal Court, after a bench conference concerning scheduling, he said the case should go out. They are ready. There is no guarantee they would be ready later. This is forthwith to trial 11. Part 11, Room 623 in Supreme Court as of now with Judge Michael A. Gross, who is an acting JSC.
Right.
In Bronx County and a criminal court judge in the same county.
That's correct, Your Honor.
And then later that day, the non-jury trial commenced in the Supreme Court building.
That's correct, Your Honor.
Does it matter what building it actually commenced? I mean,
it depends. I believe that its determination as to whether Judge Gross was hearing this as an acting Supreme Court justice or as a criminal court judge.
What exactly, in your view, demonstrates that he was hearing it as an acting Supreme Court justice?
I believe by the determination that it was being sent to Part 11 of the Supreme Court.
The language in the transcript that says we send this to Part 11 of the Supreme Court?
That's correct.
Couldn't that have been a reference to a room rather than to a jurisdictional entity?
There's no Part 11 in criminal court.
Right. There is no Part 11.
But isn't it, yeah, couldn't, yeah, if he said go to room 338 across the street, he presumed that wouldn't imply that you were to go into Supreme Court.
That's correct.
Couldn't this just been a way of saying the same thing?
I think that perhaps it could be, but I think what we have on the record as it exists, that it says that it went to the Supreme Court, and we normally go by what's stated in the transcript. And so, but again, if there are true questions about this, and I think, both sides can make a cognizable argument as to where it was actually heard.
Okay. You'll have your 30 seconds after we hear from Ms. Whetstone on behalf of the people.
May it please the Court, Kayona Whetstone for the people of Bronx County. Your Honors, this is not a transfer case. This was a case tried in criminal court.
If you're right, doesn't he get to go to the appellate term?
It could go to the appellate term. We don't believe that that's necessary. The appellate division is the court that actually created the appellate term, and so they do have jurisdiction to hear the case, and therefore it could be affirmed.
And they both act as intermediate appellate courts.
Yes. For judicial economy reasons, we don't believe that it really
is there something that says it's okay for the appellate division to hear criminal court appeals?
Article 6, Section 8 of the Constitution, and CPL 45060, subsection 4, all talk about the jurisdiction and the power of the appellate division and the creation of the appellate term. Your Honors, for judicial economy purposes, we believe it's not necessary that it go back to the appellate term. However, if that is what you deem appropriate, we would be.
Well, you're clearly right as a matter of judicial economy. I'm just trying to get at whether there's some provision of law somewhere that says it's okay to indulge in this form of judicial economy.
There is no provision that says it's not okay.
If we disagree with you that this was still a criminal court proceeding, and we think it's a Supreme Court proceeding, what happens then?
Well, Your Honors.
Because there was no rule in place, correct?
Yes, there is no transfer order in place, as was the case in Correa and Mack. And so that could pose a problem for us. However, if we believe this conviction could still be upheld if you believe that there are constitutional provisions that are self-executing that would allow the Supreme Court to have jurisdiction to hear.
So what would happen with the appellate division review of this case? I mean, assuming it was okay for Judge Gross, was it, to hear this case, whether he was wearing the hat of an acting JSC or a criminal court judge, the appeal has been argued, there's been a decision on the merits, because obviously the decision didn't say anything about this. But there's a decision on the merits in your case. What happens to that decision? That would be nullified? They would hear it, the appellate term then would hear it on the merits de novo? Is that what would happen?
Your Honor, I believe that the appellate term could hear it de novo. I don't believe, again, as we said, that that's necessary because the appellate division, we do believe, has the authority to hear this case.
And the appellate term is created by the appellate division?
Yes.
And it only gets its powers from the appellate division,
Yes.
from the PJ, from the presiding
Yes.
justice.
And the fact that, you know, any confusion is really on the onus of the defendant here because he never said anything about what court is this. There was never any question in his mind about whether or not this was Supreme Court or criminal court. It was clear that all of this transpired before any of the transfer orders were signed or even went into effect. And so,
should we talk about the merits of this case here? I mean, assuming that we're going to uphold, we uphold what the appellate division did here, decided this case on the merits. It held that the accusatory instrument was facially sufficient. Should we get into a discussion of the merits?
Your Honors, first we want to say that the defendant did not preserve his sufficiency claims. As far as facial sufficiency goes, this information was proper. It was valid. It complied with the CPL. It alleged each and every element of the crime. It gave adequate notice of the charges, so there are no double jeopardy issues. The defendant was able to prepare a defense, and therefore, the finding of the appellate division was proper, and there is no need to go any further.
Okay.
So unless the Court has any more questions, the people rest on our submission.
Okay, we're fine. All right. What about the facial sufficiency of the accusatory instrument?
I believe that, as we set forth in our papers, that it was not facially sufficient, and we would ask this Court, if it reached the merits, to reverse the decision of the appellate division. However, we did want to point out that the people are now taking an inconsistent position here, because when they had answered in Mr. Cepeda's case, which was one of the other two, along with Mr. Correa and Mr. Mack, after the case had been fully briefed and fully argued in the appellate division, they argued to the appellate division that they had no jurisdiction over that appeal and that it needed to be transferred back to the appellate term. They can't come into this Court and say, well, if it's in this Court, no, it doesn't have to go back. But in Mr. Cepeda's case, if the determination is judicial economy, they have taken a completely different position in Mr. Cepeda on a related case, and that case has been transferred back.
Okay.
Thank you.
Thank you. All right. Mr. Lucenti. All right. So you represent the defendant.
Yes,
Right.
João Fernandes.
João Fernandes. Okay.
And I'd like to reserve 3 minutes for rebuttal.
Fine. Thanks.
I'd like to, we're well into the discussion of these issues, and I'd like to really focus my time on following up on some of the things that have come up. Obviously, the common link between this case and those just argued is CPL 21005. We would maintain that this statute is a subject matter jurisdiction statute. It is jurisdictional. The reference was made to Prizer's commentary earlier, and I think the question came up as to whether that actually referred to trial jurisdiction. And in fact, he states in his commentary that 2105 is the limitation on Superior Court trial jurisdiction.
We're not bound by commentary.
You're certainly not, but it's
some
yes, it's meaningful.
Persuasive authority.
What the people have attempted to do really is to make very selective interpretation of the statute, to focus on only one aspect of it, namely insisting that it's, quote, a mandate to prosecutors. Well, in fact, yes, it's a mandate to prosecutors, but it does other things as well. It does what it says it does. It states how you get into the Superior Court in a misdemeanor case by indictment or SCI. Clearly, that's a restriction which, as I say, says what it says. It's the plain meaning of the statute. You do not need all the special interpretation, fairly creative, that the people have gone through in discussing various aspects of it. As I think has been mentioned, the fact that it's dealing with the titles of the statutes of section CPL 10 versus 21005, one being with jurisdiction, the other dealing with the procedures, as 21005 does, the titles really don't detract from the clear, plain meaning of the statute.
Why do you care? Why does your client care whether or not this goes to an integrated domestic violence part or not?
Well, I was going to actually add something to answer that question that actually I don't think has been touched on yet in terms of the policy behind the statute. What indictment opportunity does is it gives a further added heightened screening opportunity at the beginning of the case. I mean, that's what grand juries do, and that's an important function. I don't think it should be overlooked. In fact, it's a very important function.
But if you prevail, not every case like yours is going to get indicted. They'll just stay in the separate parts.
No, it won't, but that'll be part of the mix, and the defendant will always have the right to have that opportunity if it goes forward. So that's a significant consideration. I would point out, getting back to the
But isn't the supporting deposition in criminal court play the same function as a grand jury, perform the same function?
Well, I don't think so. A grand jury has all sorts of persons on it, and they're free to do what grand juries do. They vote for an indictment or against it. It's simply a different procedure. I don't think it's exactly the same. And that's why you have grand juries. And
Are you saying that individuals similarly situated to Mr. Hernandez here want to be indicted before a grand jury instead of having a misdemeanors?
Well, that's a choice. That's the policy behind the indictment procedure.
But is it the defendant's choice or it's the people's choice?
Well, it's the people's choice, but it's an opportunity.
Because I thought the question that Judge Reed was asking you is what's the advantage to your client? And I don't see a lot of advantage to your client in being indicted. Maybe I'm wrong.
Well, no, that's possibly true, but at least it's a consideration. And I think it has been stated in cases that one of the purposes behind 21005 was to offer grand jury consideration on a broader basis than otherwise existed. I'm not sure how much further you can go. As Mr. Ferguson pointed out, I think there isn't not necessarily any revealing legislative history on this. So I think that's as far as you could go on that. I would like to point out, though, on the question of whether this is a jurisdictional statute, that this focus on the mandate to the prosecutor, because the statute uses the word, 21005 uses the word prosecuting. If one were to take that argument and apply it, say, for instance, to the double jeopardy bars under the CPL, those provisions are also worded in terms of the prosecutor. And they say you shall not be prosecuted, and they use that word a couple times. So, I mean, no, I don't think anyone would argue.
Well, those are doesn't that codify constitutional requirements? Same with the speedy trial. You have statutory speedy trial provisions, right. You have constitutional speedy trial provisions.
And presumably, if the people's logic applied, you might be able to wish away the provision because it's directed to a prosecution, which is presumably a prosecutor. I'm just pointing out that the people's argument focusing on the so-called mandate to the prosecutor is way too constrained and really
I don't think that I think here they're applying it to this particular statute, this particular situation. But you're fearful that this would have ramifications?
I don't think it would necessarily go that far. I'm just saying it's inconsistent with the reading of statutes and constitutional provisions in general. It frankly doesn't make any sense.
And what's the exact disposition that you're looking for in this case?
Well, we'd ask that the charges be dismissed.
Mr. Lucendi, one of the questions I was asking earlier, is this, when a case like this, yours is an IDV case, right?
Yes, it is.
All right. And the misdemeanor is moved up to Superior Court. Is it sometimes joined with civil matters?
I'm not sure whether it has been. After you asked the question, I looked at the provisions themselves, the orders creating the IDV parts, and I believe it could be.
Yeah, I'm just not certain. It was my understanding in certain situations where it can be joined with an ongoing divorce action, or, you know, the family court custody or visitation fight is pulled in, and there's one part where this integrated domestic violence part is handled. And I was curious if you had any experience with that, because obviously you got a beyond a reasonable doubt standard on one part, you got a preponderance of the evidence on another part, and then you get into the issues of a defendant saying, do I compromise my visitation by going to trial on this? I didn't know if that was any part of your case or was any part of your experience.
Well, not part of my experience, but I would respond that I think it's a possibility under the way the IDV transfer orders have been written.
Is your client under supervised visitation or any other supervision required by the IDV part?
I don't believe at this time. I think
so if you got the disposition you were asking for, what would happen if there is any other of these supervisory or counseling mandates? Would they also disappear?
They might. I don't know that they would disappear. They could be reconsidered.
What about an order of protection? Would that be nullified?
If it's nullified, it would seem to me it would be a simple matter, if there are grounds for an order of protection, to go back in and get it immediately again. So I don't really think that would involve anything falling between the cracks.
But you would require them to go back either to family court or to criminal court for that order of protection?
So we'd have dual or triple proceedings again. We'd go back.
Well, there could be, but
to the former procedures.
The problem is that, you know, we would maintain any time the prosecuting authorities end up actually violating statutory, valid statute, that something needs to be done about it. And in this case, that might be.
And if this order of proceeding generated from a violation of a visitation order, for example, in a Supreme Court matrimonial action, they'd have to go back to the Supreme Court for that piece.
Yes, they would be considered, yes.
Explain to me why, if you prevail, you think you're entitled to dismissal of the charges?
Well, we cited this Court's law in People v. Burwell, People v. Flynn. It's the sort of case where I think it's appropriate for full dismissal. Now, the people have argued that it's, to the contrary, that it's too serious to warrant that, but it involved essentially a domestic dispute between the defendant and the...
You're saying essentially it's more trouble than it's worth.
That's one way of putting it, and I think
doesn't that suggest that maybe these IDV parts are a good idea?
I wouldn't necessarily say so. No. I think they have to comply with the provisions of 2105.
What you're saying, whether they're a good idea or not isn't the issue. You've got a statute.
No. Yeah. It's a problem having a statute, having a set of procedures which are unauthorized because of the statute.
So it's your position that if there's a problem, it's up to the legislature to fix it?
It could be fixed by the legislature. In fact, this Court knows that there were initial attempts to go to the legislature to give the sort of authorization to create these sorts of courts, and they were initially refused. But that is an avenue that could be used now. Unless the court has further questions at this point.
Unless you want to talk about the merits, because you're claiming that there was highly inflammatory evidence of uncharged crimes and...
Yes. Well, I think essentially the problem is there was evidence adduced as to, as you said, an uncharged crime by my client. And we raised that in the appellate division briefs. But there was no evidence of that actually adduced at trial. So we think it was a violation of our client's rights.
All right. Thank you so much. Okay, I lost my sheet. Ms. Mandel, Jody Mandel. Okay. Maybe you could answer Judge Piggott's question, because I'm curious too. Do matrimonials get tried in integrated domestic violence parts?
Yes. The integrated domestic violence part is a problem-solving court where one judge has authority over the criminal, matrimonial, and family court matters of one family where the issue is domestic violence. So the court does hear them, but they don't hear those trials at the same time. The criminal trial can happen on one date or a number of dates, and then the matrimonial or family court matters are heard on other dates.
And what's the benefit to the family?
The benefit to the family is that there's greater consistency because there's informed judicial decision-making. That judge knows what the issues are that are facing this family and can make a decision knowing there's a criminal case, there's violence in the home, and what should the decision be where there's child custody or support or matrimonial issues.
As opposed to having to adjourn a matrimonial trial, let's say, to let one of the litigants go to family court to get an order of protection or go to criminal court to get an order of protection, et cetera, and to litigate there.
That's correct. And then they're before another trier of fact that isn't aware of all the issues facing that family. And that's why these parts were established, and that's why they're working.
It's probably a small element in the whole thing, but one of the concerns that by matrimonial lawyers in particular have talked about is they may be forced to compromise someone's rights. In other words, if you got a judge who's already convinced that there's been domestic violence, they now risk visitation or custody or maintenance because this judge has already made a determination, even though the person, usually the husband, says he's not guilty, but he's been accused of domestic violence, and there's a cloud of concern over the case that he can't or she can't in some instances escape.
Well, there are a number of answers to that. First of all, the answer to that is that's not necessarily a bad thing. That's a good thing.
Well, no, innocence until proven guilty is a good thing, and that's my point. In other words, if you're already in court and one of the spouses has charged the other one with sexual abuse or physical abuse that is totally made up, but makes the allegation knowing that now that there's an extra arrow in his or her quiver in terms of settling the matrimonial and or settling the custody or visitation, that can be troubling. I emphasize it could be a small number of cases. I don't think we're fooling anybody to say that generally these cases are a good thing to have in that way. But I'm curious as to whether or not there's a provision or a situation where if someone does challenge the efficacy of this type of procedure, that we unbundle. In other words, if someone were to say, I think that this is going to have an influence on some very serious issues I've got coming up on the family court issues, on the family issues, or on my matrimonial, Judge, I'd prefer if this would be tried somewhere else. Can you give it to a different judge?
That's a possibility. But the fact is, if these issues are present in a case, whether they're heard by the same trier of fact or not, they're still present in that case.
Yes, but Judge Piggott's point is that an individual litigant might think it was advantageous to have separate triers.
That's possible.
Yeah.
And if the defendant had made a showing that supported the cases being unbundled, then a court could consider that and unbundle them in its discretion. But that's not what happened in this case, and I'm not saying that that's foreclosed in any case in the integrated domestic violence part. But And I'd also like to address defendant's argument here that we're taking 210.05 out of context. What the people are doing is putting 210.05 in its context. And that is, the context is that Section 7 of the Constitution says that the Supreme Court has unlimited jurisdiction, original general jurisdiction. This Court's decisions have called that unlimited and unqualified. And the whole purpose, and this answers Judge Piggott's question before, why are the people limited to bringing cases in Supreme Court by indictment or Superior Court information? Well, the criminal court was set up, and this Court held that in the Davis case recently. The criminal court was set up for administrative efficiency. So why are the people limited? Because there's a gatekeeper. The people are supposed to bring misdemeanor cases in criminal court, and the people do bring misdemeanor cases in criminal court. These cases, in the IDV part, are not gotten in through the back door, has been argued here today. It's not the people's decision to transfer the cases from criminal court to Supreme Court. It's the court's decision. Because of this organized initiative that was approved by the Administrative Board of the Courts and this Court, that these cases belong in Supreme Court. So it's not a backdoor way for the people to get in. And the other context is the CPL's jurisdictional sections say that the Supreme Court has trial jurisdiction over misdemeanors that's concurrent with that of the criminal court.
I think we appreciate that argument, but I think the other side of that argument is this, that you can't, the people can't bring a misdemeanor. You can't, let's take an aggravated harassment case. You can't take that to Supreme Court without indicting it or an SCI. You can't take it, you can take it to city court, to criminal court, right?
Yes.
All right. What the court system has now done is said, don't worry about that. Here's what we're going to do. Bring it where the only place you can, so you don't have to do the SCI or the grand jury. And then we'll convert the judge to a Supreme, and you've got it just as if you'd taken a grand jury or an SCI. But you don't have to get the defendant's consent for the SCI, and you don't have to bother those 23 people across the street.
That's correct.
Doesn't that seem a little odd? And that's why I wonder, why in the first place do you have to have an SCI or a grand jury indictment for a criminal case in Supreme Court? And if there's a valid reason for it, aren't we avoiding that valid reason?
No, Your Honor, you're not. The fact is, that's a gatekeeping provision. The people can't make that decision because the criminal court was set up to bring misdemeanors, and that's where the people go with misdemeanors. This isn't a willy-nilly decision saying...
I'm not suggesting that. Please, I don't want to get into an argument with you. What I'm trying to say is, why don't we just repeal 210? Why don't we simply say that the district attorney, the prosecutors, can bring SCIs and or don't need an SCI and don't need a grand jury indictment to bring a misdemeanor to the Supreme Court?
Because the criminal court needs a function. And the criminal court was set up for administrative efficiency. So the Supreme Court doesn't necessarily need every case.
In Erie County, the criminal court is the city court of Buffalo. They have a very valid reason. They have jurisdiction in a city of about 300,000 people. They're elected by those people, and they do this job. If this is brought to Erie County, we say, okay, City of Buffalo judges, from now on what you do is hear arraignments. All of those cases that you used to hear about the people in the City of Buffalo, they're going to be heard by the elected Supreme Court judges from the other 8 counties. And it's fine. I'm not suggesting that there's something untoward about that, but you can see the difference in terms of geographic jurisdiction and who's going to hear your case. You pick a jury in the City of Buffalo, you're getting a City of Buffalo jury. You pick a jury in Supreme Court, you're getting an 8th Judicial District or an Erie County jury, which is substantially different. And the OCA is now making the determination that you're always going to get an Erie County jury.
If the chief judge and the chief administrator of the courts find that a certain procedure in a certain county promotes the administration of justice and wants to set it up that way, they can do that.
Please don't misunderstand me. I understand all of that. What I'm saying is, why in the first instance, forget all of this, why 10 years ago couldn't you bring a misdemeanor in Supreme Court? And forget efficiency. I mean, why couldn't you do that? I mean, it seems so simple. You've got an aggravated harassment. You can walk across the street and file the misdemeanor complaint in Supreme Court.
Well, 2105 says the people can't do that.
And why?
Are you saying there's a distinction who the decision maker is, that the legislature has entrusted judges and administrators with more discretion than it entrusted to prosecutors?
Absolutely, Your Honor. And the, as Judge Acosta in the dissent in Correa set forth, the legislative history of 2105 springs from Article I, Section 6, which requires an indictment. And that's why the 2105 is the embodiment of that.
Well, but Article I, Section 6 doesn't require an indictment for misdemeanors.
No, no. It requires an indictment for felony cases in Supreme Court. And 2105 sprang from the provisions that came from Article I, Section 6. And so that's all it is. It's the people want to bring a felony in Supreme Court, they need an indictment or a Superior Court information. In addition, our interpretation of 2105 complies with the rules of statutory construction. The Court should not read in exceptions to the statute where they don't exist. The legislature said grand jury action was necessary for trial jurisdiction over petty offenses, but didn't say that it was necessary over misdemeanors. And they said grand jury action was necessary for preliminary jurisdiction and not trial jurisdiction. That's why it shouldn't be read in. In addition, it avoids an unconstitutional interpretation of the statute because the legislature can't restrict the jurisdiction of Supreme Court. 2105 should not be read to restrict that jurisdiction. And in addition, it would avoid an anomalous result so that the prosecutor would be the only party that could decide when misdemeanors are heard in Supreme Court. The Court just wouldn't have that power if you took the defendant's reading of the statute. So that if we went to the grand jury with a misdemeanor charge and the grand jury agreed it should be sent to Supreme Court, then we would be the only ones who get to decide when misdemeanors are heard. In addition, I'd like to respond to the equal protection issue just briefly, and that is the defendants are in no different position now than they were before these transfers were effected. When you were tried for an A misdemeanor in criminal court, you got a 6-person jury. Now when you're tried for an A misdemeanor in Supreme Court, you get an unindicted A misdemeanor, you get a 6-person jury. So it's still only the unindicted defendants who get 6-person juries and the indicted defendants who get 12-person juries. The same situation was before and after the transfer. Mr. Lucenti was arguing that defendant wanted his case presented to the grand jury here. Well, he always had that option under 17025. He could ask the court to have his case presented to the grand jury.
What about the appeal? Don't you have a different appellate court?
Yes. But
you say who cares?
Right. And as we discussed before, the appellate term is an arm of the appellate division, and there really is no difference there. So for all of these reasons, we ask the Court to affirm the decision of the court below and find that these transfers were valid and that the Court had jurisdiction over the case.
Thank you, Ms. Mandel. Mr. Lucenti, you reserve 3 minutes. Do you need it? All right. Thank you so much. All right. All of you, thank you.